Right, welcome everyone to the awesome world of tax residency. I'd like to talk to you today about tax residency in New Zealand and put a question to you: is anyone not resident here? Tax residency in New Zealand. I'm going to focus particularly on the position when advising individuals. Most of us in our various workplaces will be advising a range of entities, all of which are impacted by residency, being individuals, legal persons such as companies and limited partnerships, and also with particularly in private client fields, trust. So we'll look at the relevance, the legislative position, the statute sections in the Income Tax Act, and then I'd like to take you through the evolving case law scenario for individuals. And we'll look at particularly case 10/2013, whether it is definitive or disastrous, and then we'll have some conclusions at the end. So the context, the journey from Applegate to case U17 was one where the jurisprudence had been steadily evolving. Clarity was appreciably present for advisors and their clients and the revenue. And then came case 10/2013, and what was it about this case that caused such a reaction that the Inland Revenue elected to issue an 89-page interpretation statement to restore clarity? Let's look at this together. First we'll start with relevance. Now, why is this area so important? In Germany, during the 1930s, a Jewish industrialist saw that to remain in Germany would mean death for his family. He was forced to liquidate his business and interests, and resolved his family would never be in a financial position where their wealth was captured in one country, such that they never had a means of escape. So when he left Germany, he left some funds under private bank control in Luxembourg. He went to, in this case, the United Kingdom for a while, and then eventually settled in the US. Built a global business. They paid tax on their earnings. Billions of dollars of tax were actually paid across generations. When the IRS eventually approached one of their descendants after the 2010-11 G8 crackdown, and the IRS said, "We know you pay your taxes, etc., but we suspect your great-grandfather left some funds behind in Europe. Two choices: tell us we're right and give us half of the contents of the account, and we'll label you a tax cheat, but one who's paid their debt. Or we'll go look for it, and if we find it, you go to jail." So question us advisors: what gives the government rights to this behaviour? What gives the government rights to tell what persons that they owe tax? And the answer is it's all around the rules around residency. And with the exception of the United States and one other country, most of the countries in the world tax on the basis of their concept of residency. So in New Zealand, we're a nation of globally mobile people. We have regular clients with children moving overseas. We have businesses that are involved in international trade, generating income. We have a lot of trusts managed in and through New Zealand that designed to hold wealth across borders and across generations. The philosophy and design of understanding of the concept of residency shapes New Zealand's international treaties. That philosophical model determines the basis of things like our double tax treaties with there's at least 36 countries we have those with, tax exchange information agreements, which are principally extracting information out of other countries, but in New Zealand also honouring some obligations there, and also its intergovernmental agreements, such as the one recently signed where New Zealand has adopted the American FATCA rules. So moving to the law, and I do challenge us to be aware that this is a crucial area and an evolving area. Let's look at what the law says. So the notion of residence for tax purposes is closely tied to the incidence of tax liability in New Zealand. So in other words, New Zealand taxes its tax residents on their worldwide income, whether they're individuals, a legal person, or a trust. And I've got across on the right there a table for you that shows the relevant sections. Now, let's look at the one with the individuals, for instance. So looking up here, there are two key bases upon which one might be a resident here. And you're a resident if you have a permanent place of abode in New Zealand, and that's under YD12, or you're in New Zealand for more than 183 days in a 12-month period. Now note, residency requires only one of those dots to apply. So it doesn't matter if you've been here for less than 183 days if you've acquired a permanent place of abode. Similarly with the company, if it's incorporated here in New Zealand, or its head office is in New Zealand, or its centre of management is in New Zealand, or its directors in their capacity exercise control in New Zealand, any one of those can apply. So there are instances where a company is not registered in New Zealand, it might be registered in Hong Kong, but it is involved actively with its centre of management in New Zealand. And cases like that include trust and asset management companies and some of the financial entities. They can be captured as being New Zealand resident even though the companies are in Hong Kong and the directors might be in Hong Kong and the UK. I'm going to focus for this presentation though on individuals or natural persons. And a natural person tax resident in New Zealand must account for their assessable income in New Zealand regardless of source, so it's a worldwide income tax. Question then is, so can you leave? The core issue the courts have been asked to look at is a question of what comprises a permanent place of abode. Okay, the number of day test is ordinarily sufficient even for a lawyer to calculate, which means that most humans get it very quickly. And it's the phrase permanent place of abode that is open for debate. Now on the table across on the right here I've done the same thing as how not to be a resident. The difference between this table and the previous one is that all relevant points must apply. And so in the previous table, any one, you're a resident. In order to quote unquote escape the net, all of the points in your relevant column must apply. So back to general commentary. In pursuit of clarity, because in the case of the individual the turnkey phrase is this permanent place of abode, the pursuit of clarity has been left to the court. The consequence of lack of clarity is that taxpayers can take a wrong position under the Tax Administration Act, and there can be poor advice by their advisors. So let's look at the evolution by case law. In the beginning was Applegate. Okay, now Applegate is one where the court invested considerable time wrestling with the impact of the word permanent in front of the rest of the phrase place of abode. So in other words, what is the difference between one's place of abode and a permanent place of abode? Fisher J. there concluded that the proper construction is a taxpayer's fixed and habitual place of abode. Okay, the court cautioned that residence is distinct from domicile and is a lesser test. And that caution has to the large part been remembered by the New Zealand courts, and with the exception of the case we'll look at the end. Interestingly, at a similar time, also in 1979, the New Zealand courts were asked to look at this whole issue of residency in the geothermal case, and BTJ cited Applegate and added, for what he hoped greater comprehension, the statement, the centre is the centre of gravity for the time being of the life of the person concerned, the place where the normal course of the taxpayer's life occurs. So where they really, in the common language, would say, this is my home. These cases began to build a picture of what. So these began to give a picture of what was envisaged under the Act. In short, not dealing with mere property used during a holiday or a short-term visit to New Zealand, but really focusing on a place where the normal course of a person's life occurs. Having read these two cases, the next decisions show that the relevant taxpayers clearly never sought legal or accounting advice before taking their position. In case F138, a lecturer left home in New Zealand for a 1-year sabbatical. They didn't account for tax to New Zealand for that year that they were away. BTJ explained that the permanent place of abode meant a lasting or enduring place of abode as opposed to a temporary residence. That is, a place where one usually lives. The taxpayer clearly maintained their New Zealand residence. But wait, there's more. Case H97, the taxpayer didn't have his own home, didn't own one, and hadn't leased it. He was a bit of a nomad in New Zealand, but kept coming back to his parents' place. Secured a contract to work in the mines in Papua New Guinea, and had been living with his parents at the time he got that agreement. 6 months into the contract, he was evacuated back to New Zealand for health reasons, where he returned to his parents' home. For some reason, this particular person, cartoon picture to the right, decided he wasn't tax resident in New Zealand. The case is interesting in that it states one's personal presence is not determinative of one's permanent place of abode. So in other words, you don't have to be physically present in New Zealand to maintain a permanent place of abode here. A bit of a worry. 2, he hadn't established a permanent place of abode outside New Zealand. Okay, so back to our table, that means that there was still one of those points that qualified him as a New Zealand resident. 3, particularly, he hadn't changed his permanent place of abode from the residence of his parents. This was a slight expansion of the concept, but not outside the bounds of Applegate's analysis, and still really it makes sense. Case J41 involved a taxpayer who was originally a British citizen who had moved to New Zealand and married a Kiwi. He and his wife leased out the New Zealand home, boarded a ship and headed off on the Great World Tour. They toured Europe for 14 months based from his brother's UK home. He tried to claim that he wasn't actually resident in New Zealand for that relevant year, but he also tried to claim to the British authorities he wasn't really resident there either, and as some clients would want to do, didn't help himself by filing a declaration with the UK that his home was in New Zealand. Now this involved some discussions around the double tax agreement with the UK, but that's really over to the material decision is Barbara J's conclusion. We said a mere accessibility to a property is sufficient to qualify so long as the taxpayer's association with that home had durability. Now on the face of it, that's a bit of an expansion of the concept, but when you think about his qualifying statement, so long as the taxpayer's association with that home had durability, that still actually makes sense. Barbara also said that the taxpayer's enduring relationship was with the New Zealand home property, had remained his permanent place of abode, to which he ultimately returned. Okay, that's fair enough. We're getting some clarity there. So the evolution of Applegate beyond the relevant tax year, but still looking at the long term of permanent connection. In other words, starting to sound a little bit like domicile, which is where do you call home, but not quite outside the bounds of reality. But wait folks, there's more. Okay, no TV-like headline. This is an amazing case. Case U17 is alright. The taxpayer left his home in pursuit of business opportunities in Singapore. He was a bit of a hard man and left his family. And family remaining in New Zealand, in fact, were genuinely estranged. They hated him, didn't talk to him. Taxpayer established fresh links in Singapore and even sold out of his New Zealand business interests. He did eventually buy a farm in New Zealand, and he had 2 reasons for that. Principally it was investment reason, because he could use it as leverage to borrow money from the bank for his Singaporean business when it was going through a tough period. But he also justified it to himself in that it provided a home for his family. A couple of things to note. One, he actually had never lived on that home, so unlike previous cases where people had all lived in the property and then returned to it, he'd never lived on this farm and he actually had no intention of living there. Second, he had established a permanent place of abode in Singapore. He'd joined to clubs, gone onto his fitness gym, everything was all based for him in Singapore. Life was happening there. And 3, he did not have any enduring relationship with a New Zealand property, such as he would describe it as his home. It was literally just an investment vehicle. This case gets a big tick. At this point you could be forgiven for thinking that matters were finally clear in New Zealand. In other words, really important, where does the person see his home? Do they have an enduring connection with the property? Whether or not the property is leased out, rented out, or otherwise, is it available to them, and is it their long-term home? And then came case 10/2013. The decision is quite amazing. In my view, and I'm speaking purely conjecturally, it prompted the IRD to rescue the day by issuing the 89-page interpretation statement in an endeavour to bring matters back into balance that had been achieved by the time of case U17. It also has left many convinced that Her Honour wrote this decision in a Dutch coffee house, and proprietary denies me from expanding on that. So what is this case really about, and why is it so amazing? Here a taxpayer left his family and been based offshore for over 10 years. Okay, when his wife came back to New Zealand, they hadn't owned a property. She came back and, with part of the separation arrangements, bought a property herself. So on the face of it, it's surely a simple repeat of the Singaporean business case, only clearer, because here the taxpayer's wife had returned, bought a home for herself and the children where he had never lived. So he had no connection with this property that she bought. She certainly didn't want him to have any connection because he was out. And there was no enduring relationship with that home property, or in his mind either. B, the taxpayer had a 1% shareholding at the time the case was asked to look at in an investment company that owned rental property in New Zealand. Who had the other 99%? His ex-wife. Now these properties were tenanted formally and they were not available to him. Moreover, he had no emotional nexus with those properties. They weren't home to him. They were just some investments that his wife had and he had a share in for income purposes. Also, at the time, he had structured his affairs outside New Zealand. His bank accounts were in the US and Australia, and he did that with the clear intention of retiring from work as a mercenary. That's what he was. He was a mercenary in Iraq and Papua New Guinea. So you think, that's pretty clear. There's no home that he owns. There's no home that he considers his family abode for him to live in and retire in New Zealand. He's off to Australia once he's finished in Iraq. Hasn't been here for 10 years. Doesn't really call the place home and no desire to return here. I would be with you on that. But what the court held is, 1, he had a permanent place of abode in New Zealand. 2, his relationship with his ex-wife and children, in this case the ex-wife was his financial manager, meant he had an enduring relationship with New Zealand. 3, his single share in a rental company meant that he had an available dwelling, and that in the judge's opinion he could coerce the ex-wife to evict some fee income-paying tenants from one of her company's rental properties so that he could bludge off free in that home. Really strange. Fortunately, as I said, the ID issued an interpretation statement, and equally importantly, the case is under appeal to the High Court. It does show, however, that post the global credit crunch, there is a lot of pressure on the regulatory bodies to ensure they're getting every ounce of tax they possibly can out of the system. In my experience, 99% of the time, what's being sought is appropriate and reasonable, but occasionally we get a blip on the radar like this, and it's just extreme. And the caution to us as advisors is to be very, very thorough in how we look at a client's situation, and don't ignore the question of where is this person tax resident. In conclusion, with individuals pending the appeal of case 2013, the list of New Zealand residents is potentially quite extensive. My view is to follow the IRD interpretation statement and to continue to look at where a person owns or leases property long term in New Zealand, where they see home, and where their enduring connections are. There is some development from the OECD around what they call centres of vital interest, and that is also helpful, and the court do seem to be trying to look at that. So, look at where the client naturally engages and interacts, and look at the long-term relationships with companies. I didn't really talk into that. With trusts, this is an area to be aware of because it impacts individuals. So there's quite a close connection between individuals and trusts. And with the advent of FATCA from the Americans, this will impact trusts, as not all trusts are resident in New Zealand, but they might have a New Zealand resident trustee who's affected. Also, if we've got clients that are ordinarily resident in New Zealand and they establish a trust and one of their children marries an American citizen who may themselves be resident physically in New Zealand, do be aware that there will be some complications there as well. Anyway, really appreciate you listening. Thank you for that, and wish everybody all the best.